Welcome once again to Lehto's Law. Here's Steve Lehto.
This video will be longer, but we have a story for the ages. We have the best example of the worst use of AI, of ChatGPT. I've talked before about people using it when they shouldn't and how stupid it makes them look, and especially because a lot of them have been attorneys. Attorneys have filed documents with courts that are filled with hallucinations, and it was all stuff invented by ChatGPT. And when lawyers do that, they deserve to get in trouble because they're supposed to verify everything they file with the court as being authentic and correct and true. And it turns out some of the stuff is literally just imaginary stuff invented by this program. So you might say, Steve, what would be an even better story about that? Keep in mind, we're looking for the stories where things are taken to the extreme. And Nicholas sent me a note with a link to an opinion by a federal court judge out of the United States District Court, District of Minnesota. Okay? This is the opinion. And in this case, the judge gets to choose somebody out for filing with the court an affidavit that was created partially by ChatGPT. The affidavit was provided by somebody who claims to be an expert in AI. They know all about AI, and they want to come into court and testify and explain to the court what's going on here. And the affidavit they filed with the court was partially created by ChatGPT, and yeah, the judge is not happy. So it's going to be a longer video. I apologize. The case is called Christopher Coles versus Keith Ellison, who, by the way, is the Attorney General of Minnesota. And it was the Attorney General's office that submitted the affidavit to the court, but it was signed by an expert under the penalty of perjury. And again, the judge was not happy. So the plaintiffs moved to exclude an expert declaration offered by the Attorney General in his official capacity as the AG of Minnesota. And recognizing errors in one of the declarations, the Attorney General filed for a motion asking the court to grant it permission to submit a new affidavit to replace the other one. But the plaintiffs objected to that and have also filed a motion asking the court to strike the affidavit and also some other things which aren't that important here, but I'll touch on them. But the court partially granted and then partially denied the motion of the plaintiffs, but denied the motion of the AG to replace the affidavit with one that was not so defective. So just so you know, the case involves Minnesota law, which under certain circumstances prohibits deep fakes, if they're used in the political process in an attempt to hurt a politician or a political candidate. And so plaintiffs are challenging the statute on First Amendment grounds, and they've sought a preliminary injunction. So the AG is defending the law. With his responsive memo in opposition to the motion, the AG submitted two expert declarations, one from a professor at the University of Washington, who is some kind of expert, and another from a professor of communication at Stanford University and director of the Stanford Social Media Lab. The declarations generally offer background about artificial intelligence, deepfakes, and the dangers of deepfakes to free speech and democracy. It's the second declaration, the second expert that we're going to be talking about here. So plaintiffs filed a motion to exclude both declarations, and they argued primarily about the first one by pointing out that the expert contradicted things the same expert had published previously. And the court pointed out that, you know something, experts can do that. That goes more towards their credibility, and you can cross-examine them on it all day long, but that won't keep it out entirely. However, the one that was filed by the guy who relied upon the ChatGPT, plaintiffs alleged that the professor included fabricated material in his declaration, and after reviewing plaintiffs' motion to exclude, the AG then asked if they could update it, but meanwhile, the professor admitted that his declaration inadvertently included citations to two non-existent academic articles and incorrectly cited the authors of a third article. Now, when you say it inadvertently included, that makes it sound like, oh, it's an accident. That's not his fault. You're going to find out, if you don't know this already, that the federal courts have got their own rules. And they've got a rule that says if you sign something swearing that it's true and it inadvertently isn't true, and by the way, it's something you could have figured out, that's kind of on you. These errors apparently originated from the professor's use of ChatGPT, a generative AI tool. And he used it in drafting his declaration about his expertise understanding AI. So ChatGPT provided the professor with fake citations to academic articles, which he failed to verify before including them in his declaration. Now, in response, the AG candidly acknowledged the fake citations, because what else are you going to do? And they're saying that their office had no idea. Okay, but the deadline to submit a response had already elapsed. The AG has requested the court's permission to file an amended declaration from the same guy, by the way, citing excusable neglect to allow the late filing. Plaintiffs have opposed that motion, and they continue to maintain that the fake citations in the professor's declaration taint the entirety of his opinions and render any opinion by him inadmissible. And there's a strong argument to be made that that is in fact the case, okay? So here's the deal. They do talk about the first expert. I mentioned this earlier. They point out that he supplied an affidavit to the court that completely contradicts things he said in a book he wrote, and therefore his opinion appears to be all over the road. And the court said, well, you know, the book was written 4 years ago. It's possible he's changed his mind. It's possible his position has kind of evolved. But you can bring all that on a cross-examination. The guy just simply filed an affidavit with the court because the attorney general is opposing a motion and wanted to point out, hey, I've got experts who will testify to support my position. And so the court said, look, it's understandable that an expert's opinions might change over the years, but I'll use it for what it's worth, and you get to cross-examine him on it if it ever gets to trial. But then the judge writes, the second declaration is a different matter. Attorney General concedes that the professor included citations to 2 non-existent academic articles and incorrectly cited a third. The professor admits that he used ChatGPT to assist him in drafting his declaration. And by the way, I wrote myself a little note in the margin here, which I don't often do, to point out that if you were going to cross-examine this guy, if he got to testify, you can cross-examine him about how much he's being paid to provide an opinion. And you could ask him, through a subpoena, to bring to court all of the billing information regarding his work that he did on the file. And you can ask him, by the way, how much did you bill to create the affidavit that was actually created by ChatGPT? Because we all know that ChatGPT can do in 30 seconds what it might take you or me a couple days to do. Of course, it makes up stuff, which makes it go a little faster. But the point is, did he really reduce his bill because ChatGPT was doing some of his work for him? I have a sneaky feeling that he didn't. But I'll admit, I don't know. I'm merely speculating. So the court writes a 2-word sentence, and it's actually a sentence fragment because it has no verbs. The irony. The irony. The professor is a credentialed expert on the dangers of AI and misinformation, has fallen victim to the siren call of relying too heavily on AI in a case that revolves around the dangers of AI, no less. The professor offers a detailed explanation of his drafting process to explain precisely how and why these AI hallucinated citations in his declaration came to be, and he assures the court that he stands by the substantive propositions in his declaration, even those that are supported by fake citations. Hey, I still stand by the gist of it. Well, if what you're saying stands up on its own, then why did you include those other citations? But here's the problem. The fact remains the professor submitted his declaration under penalty of perjury with fake citations. It is troubling to the court that the professor typically validates citations with a reference software when he writes academic articles, but did not do so in submitting this declaration as part of a legal filing. And so apparently somebody found out that this guy routinely writes papers, and when he writes papers, he runs them through a software that'll check them. ChatGPT wrote this for him, and he didn't bother checking that, despite the fact that he has this software that he uses. So he used ChatGPT and chose not to check it. That's another problem. So the court would expect greater diligence from attorneys, let alone an expert in AI misinformation at one of the country's most renowned academic institutions. To be clear, the court does not fault the professor for using the AI for research purposes, because it does things like speeding up processes and so on. But when attorneys and experts abdicate their independent judgment and critical thinking skills in favor of ready-made AI-generated answers, the quality of our legal profession and the court's decisional process suffer. And by the way, in case you haven't thought of this yet, all the stories we've talked about with ChatGPT and AI and stuff being filed inappropriately are just the ones that were caught and made the news. I guarantee you that some of those briefs have snuck through and nobody caught them. I'd bet money on it that we're going to discover down the road, people are going to come out and go, wait, this guy filed a brief, cited a case. I finally looked it up. It doesn't exist. So this court, federal court, adds its voice to a growing chorus of courts around the country declaring the same message: verify AI-generated content in legal submissions. And then the court gives examples of these things happening in other courts, in the Second Circuit, in Missouri, in New York. And so, court continues, to be sure, the Attorney General maintains that his office had no idea that the declaration included fake citations. Okay. Counsel for the AG sincerely apologized at oral argument for the unintentional fake citations. But the AG's attorneys are reminded that the federal rules of civil procedure, in particular, number 11, and right now, by the way, every attorney in the audience just got chills because Rule 11 sanctions are something you hear about. You file something in the court that's got serious problems and you get sanctioned under Rule 11, it's not pretty. Hasn't happened to me, but I know people it has happened to. Federal Rule Civil Procedure 11 imposes a personal, non-delegable responsibility to validate the truth and legal reasonableness of the papers filed. So you file it, it's on you. You cannot delegate that responsibility if you signed it. If you signed it, you check it. Someone else checks it, they sign it. Oh, they're not an attorney? Then you got to review it, you sign it. The court wanted to get rid of this whole, I didn't check it, my secretary checked it. The court suggests that an inquiry reasonable under the circumstances may now require attorneys to ask their witnesses whether they've used AI in drafting their declarations and what they've done to verify any AI-generated content. Nevertheless, now we're getting the meat of this. The plaintiffs argue that the declaration should be excluded in its entirety, and the court should not allow the AG to file an amended declaration. The court agrees. The court says no. That affidavit is out, and you cannot file a new one. The professor's citation to fake AI-generated sources in his declaration, even with his helpful, thorough, and plausible explanation, shatters his credibility with this court. And at a minimum, expert testimony is supposed to be reliable. More fundamentally, signing a declaration under penalty of perjury is not a mere formality. It alerts declarants, the witnesses, to the gravity of their undertaking and thereby have a meaningful effect on truth-telling and reliability. This guy and his affidavit are out. Moreover, Citing to fake sources imposes many harms, including wasting the opposing party's time and money, the court's time and resources, and reputational harms to the legal system, just to name a few. Courts therefore do not and should not make allowances for a party who cites to fake, non-existent, misleading authorities. And by the way, think about this fact, that the attorney who signs the documents that get filed with the court quite often, if they have to check the citations done by non-attorneys, that'd be very, very difficult to do. So you understand that they would rely upon their expert who's filing a thing and says, look, I've got all these authorities that say this. It'd be harder for me to check that than it would be for him to check that. So I assume those are real, and that's part of the problem. But the plaintiff's attorneys, when they discovered this, obviously are like, wait, what? But it took them time and money to do that because they're spinning their own wheels. So the consequences of citing fake AI-generated sources for attorneys and litigants are steep. The consequences should be no different for an expert offering testimony to assist the court under penalty of perjury. So here the case was, the plaintiffs had filed a motion. The AG filed a response. As part of his response, he attached affidavits of experts supporting his position. Now it turns out that one of those affidavits was written by an expert who was using ChatGPT that just made stuff up, right? So the court's saying that expert's out. And the court now also says that it does not believe that the professor intentionally cited the fake sources. And the court commends the professor and the AG for conceding and addressing the errors in the declaration. But the court cannot accept false statements, innocent or not, in an expert's declaration submitted under penalty of perjury. So the court says, not going to allow it in. It's out. So the court also denied the motion that the AG had filed for permission to file an amended declaration on behalf of that witness. And I'm going to tell you right now a pro tip. That expert just destroyed his career. He cannot, in the future, testify in court as an expert on AI, generating language, and so on. He can't do it. 10 years from now, someone calls me up and says, Steve, remember that guy who filed that affidavit on behalf of the AG of Minnesota? And I'd say, of course I do. 10 years from now. Do you want to come into court, join our team, and do nothing but cross-examine him? I'd say yes. How much do I pay you? That would be fun. Because this guy signed a document under penalty of perjury that it turns out had falsehoods in it. That by itself means that when he gets on the stand, he can be cross-examined about his credibility. Do you remember filing an affidavit in the state of Minnesota back in 2024 in a case called Coles versus Ellison? Do you remember that? Oh, you do. Let's talk about that for a bit. Filed an affidavit with the court, last sentence of which, signed and sworn before me, blah, 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 penalties of perjury. I'd have a copy of it. Oh, I'd have a copy of it. Let's talk about that. That's your signature, isn't it? That's your signature right there. That's you. You signed that under penalty of perjury. See, people don't understand. When you've got one or two things you can cross-examine someone on, you can stretch it out for dramatic purposes, not for weeks on end. And here's the thing. You might say, but Steve, what if a judge doesn't like you doing this? Oh, the judge will enjoy the show. Because the judge is going to look at anybody who hires this guy and go, you knew that's what you were going to get. You knew that when you bring this guy as an expert in, you can cross-examine him on prior statements he made under oath. This guy's done. He's done. But I don't like to celebrate in people who lose their livelihoods. He ain't losing his livelihood. He's a professor. He's going to continue being a professor, I would assume. But as an expert witness in this, he's done. He's done. Because any place he testifies, they're going to pull that out and go, hey, people, grab your popcorn. This is about to get really good. really good. And honest to God, I would, if somebody said, Steve, would you like to come in and do this guy's cross-examination? I would feel like I should be paying them. It would be so much fun. You have no idea how many times you go into court, you got witnesses on the stand, you'd like to cross-examine them, you wish you had the smoking gun, but the best you can do is go through and go, well, you said this and you actually meant this, right? Okay, you said this and it really actually should have been this. Little tweaks, right? No. This is like you break out the chainsaw. Okay, let's talk about your credibility and that affidavit you signed under penalty of perjury in federal court in Minnesota. I'd have a hard time being serious. It would be so much fun. And so I think the guy's done. But this has to be the worst example or best example, depending on which way you're looking at it, of the misuse of ChatGPT, because it was used by a guy claiming to be an expert in AI, and he used it to create his affidavit that he then signed under penalty of perjury, and it contained hallucinations that he didn't spot. So what makes him an expert now? How is he an expert if he doesn't even understand the dangers of it himself? And he's going to testify about the dangers of it. I mean, this is such a big point. I feel like I should talk about it for like another 3 days, but no one's got that kind of time. My videotape will run out. So Nicholas, thanks for sending this. This is wonderful or horrifying, depending on how you look at it. But the one thing I do worry about is the fact that I bet you other things have been filed that nobody caught. And I suspect that years from now, people will be able to run some kind of program looking for this stuff and find it. And go, oh, it turns out that in 2024, the few cases they caught were just the tip of the iceberg. And so, unfortunately, the courts, have to do something to really hammer home the point that you can't do this. So the AG files the affidavit with the court. He's under some liability because it's on his case, and when he files it, that's on him. But the signature was the expert's under penalty of perjury. That's a very serious problem. So in this case, the judge said, I'm not going to allow this affidavit. I'm throwing it out and no, they cannot amend. But as this case goes forward, that's one thing. But the witness who filed the brief, the affidavit, well, that's another story altogether. We'll see, but I suspect his career is over as far as this goes. So thanks for sending that, Nicholas. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I owe my solitude to other people.